Mescall. The purpose of this discussion is to help prepare you for your deposition in your upcoming personal injury case. I often say that the deposition is the most important day in your case that you can control. A deposition is a question and answer session. You will likely be in a conference room in my law offices. I'll be present with you. An attorney for the defendants against whom we're making a claim in this case will be asking you questions. There'll be a court reporter present. The questions will be under oath, so you'll be testifying, and your testimony or answers to those questions will have the same force and effect as if you were testifying before a judge and a jury in a court of law. This is a deposition transcript. In other words, the court reporter is going to take down every question, going to take down every one of your answers, and create a booklet like this. All of the attorneys involved in the case will have this booklet if and when your case goes to trial. The best way to ensure a trial is to give a poor showing at your deposition. That will encourage the defendants and their insurance companies to proceed to trial. The attorney for the defendants can read, with a few exceptions, almost any question and answer that you give to the jury. So in other words, if you say the accident happened on the wrong date or something along those lines, you can see that is going to come back to haunt you. That's why it's very important that we prepare for your deposition testimony. The jury will expect you to know your case, how the accident happened, your injuries and the effects of those injuries. So it's very important that we prepare. In addition to spending some time with you now through this disc to give you some general instructions, we will likely spend at least an hour with you right before your deposition to go over the particular facts of your case. So we want you to listen to what I have to say now, which are general instructions. Also make sure you review your answers to interrogatories. Those are the written questions that were sent to us by the attorneys for the defendants in this case. We answered those questions, also under oath, with your assistance. We usually attach all of the relevant information, police investigation reports, doctor's reports, hospital records. It's important that you review that information before your deposition. In particular, what you should look for is things that you said, either to an investigating police officer, a doctor, somebody else, because the other lawyers in the case for the defendants also have that information. And it's important that you're consistent as much as you honestly can be with the information that's provided in those records. For instance, if you went to the hospital by an ambulance, an EMS worker would have taken your initial complaints, gotten a history of the accident from you. It's important that you review that information so that you're familiar with it at the time of your deposition. Typically, when the deposition starts, the attorneys for the defendants will give you a couple of preliminary instructions. I want to go over them with you now. First, they will remind you that your testimony is under oath and basically that they're going to rely on it later at the trial of the case. The lawyer for the defendant will tell you if you don't understand a question, please make sure that you do not answer that question. It may sound as if that instruction is for your benefit, but I'm sure you can understand any good attorney is going to give you that instruction because they don't want to go to trial and have you make excuses for a bad answer and tell the lawyer in front of the jury that you didn't understand the question. They will come back at you at trial and say, didn't I give you this instruction before we started? So that's the reason for that instruction. The lawyer will tell you to answer the questions verbally. In other words, you can't nod or shake your head because the court reporter can't take that down. The lawyer will typically tell you not to answer a question before he finishes the question. Realize again that there's a court reporter who's taking down every question and every answer, so you can't speak over the attorney. You have to wait for him to finish his question. It's always good advice just to answer the question that the lawyer gives you. If he asks you what the weather was like on the date of the accident, you tell him what the weather was like. Don't go into detail as to how the accident happened, because I guarantee you he'll get there. The information he needs to elicit from you, he will get from you. And if you give him more information than he needs, you end up repeating yourself, particularly as to how the accident happened. The more you repeat yourself, the more the opportunity that you will contradict yourself. So just answer the question that the lawyer gives you. The only exception to that is at some point the lawyer will ask you for your complaints, your physical complaints at this time resulting from the accident, as well as your limitations. In that regard, you want to be complete and give him all of your complaints and all of your limitations resulting from the accident. I am not allowed to help you during the deposition in the sense that I cannot answer a question for you. I cannot correct you at your deposition. If you say the accident happened on the wrong date, well, we're stuck with that incorrect testimony at the time of trial, for instance. I can help you now, and that's what I'm trying to do. Like I said, I will give you some instructions now. I will also help you at the time you come into my office, and we have a discussion about your case and the issues in your case right before the deposition. What I can do at the time of your deposition is object to a question. If I think a question is misleading or unfair or it involves privileged information, I'm allowed to object. If myself or the lawyer from Mescall and Acosta in the room with you objects to a question, you should stop what you're saying, place the objection on the record, then in all likelihood you will still have to answer the question. The defendant's lawyer may rephrase or reword the question if, for instance, it was misleading or unclear or something of that nature. So those are basically the general instructions that you will hear from the defendant's attorney before the deposition starts. That will all be on the record in front of the court reporter, and that is actually part of the deposition transcript. Typically, after the initial instructions, the attorney will want to get some background information from you. One of the things they're doing is evaluating how good you are as a witness. Do you tell the truth? Do you gild the lily? Do you make things worse than they really are? Were you incorrect about a prior accident, perhaps, that you were involved in? Realize that these lawyers are not there to help you. They are there to take your case apart if they can. In other words, they're going to try to let you cut your own throat. Good example of that. They may ask you about prior accidents. Now realize that they do a search typically. The insurance industry has something called the CIB, which generally is a computer record of all accidents where an insurance company has made a payment. Could be a property damage claim you made. Could be another personal injury claim that you made. So the lawyer isn't going to necessarily help you and bring your attention to these claims, but he will ask you a question when he goes through the background information. Have you ever been injured in any other accident or injured in any other way? Have you ever been hospitalized? Those types of broad questions, and you need to think about that. Typically when we answer the interrogatories, we cover some of that information, but you want to be prepared to give them your health history, particularly anything involving litigation, any other personal injury claims. It's very important. It can be devastating to your case if the other lawyer is aware of an accident that you made a claim for in particular and you don't admit that you were injured in a prior accident. If it involves the same body part, the prior accident, such as a back or a neck, then that's that's a real difficulty for us to address if you don't disclose it to us. We can deal with that, we can work with it, we can distinguish whatever complaints you have now that you didn't have as a result of the prior accidents. But they will go through your health history in some detail. They'll go through your family history, they'll go through your education. As I touched on before, this lawyer is evaluating you. After the deposition, he will write a report back to the insurance company, and he will give his assessment of you as a witness. And that has a long way with, that will go a long way in determining the value of your case. That's why it's important that you dress well. You don't have to wear a suit and a tie or your Sunday dress, for instance, but you need to be well groomed and you need to make a good presentation, and more important than anything else, you need to know what you're talking about. You need to know the history, and you need to do your homework before the deposition. So after going through background information, likely the attorney will get into the particulars of the accident, exactly how it happened, when it happened, who was present, those sort of things. I know it's difficult. Typically what I hear when I'm preparing somebody for a deposition, it happened so fast, I really don't know what happened. Well, there is a police report, typically, or some type of incident report, or maybe a witness statement, or maybe you gave a statement shortly after the accident to somebody. You gave us information when you came to us initially. We take a detailed interview of you. So we will go through that with you, and as I said, a lot of that information is attached to your answers to interrogatory, so you need to do your homework. After 30 years of trying cases, the jury expects you to know your case. They're not real sympathetic in my experience where you don't know what happened. It's one thing if you're unconscious, I understand that, but typically in the regular case where you weren't completely knocked out, you need to know what happened. You need to know what treatment you got shortly after the accident. And there are records that were created that can help provide that information to you, so you should know it. One other thing you should be aware of is often in the initial instructions, the defense lawyer will say, hey, if you don't know the answer to a question, tell me that. That's permissible. Now that's somewhat of a lawyer's trick, because realize if you say in your deposition transcript, I don't know the answer to that question, when we get to trial, it may be they can use that information to impeach you if you say you do now know the information. For instance, if you don't know how many times you saw your doctor, how many months you went to see him, that's information you should know by studying the records. That's information I will likely want to elicit from you at the time of trial. So you should know it. And if at the time of trial you come in and say, I saw my doctor for 6 months and he gave me physical therapy, and at your deposition you said, I have no idea how long I saw my doctor, you can be certain that the defense attorney will read that question and answer to the jury. And again, that may not be at first blush of overwhelming importance, but if you get enough inconsistencies in a case, I find that the jury tends to doubt the testimony, the credible testimony that you give about the important issues of the case. So you want to be on the ball. The information that you should know, you want to know at the time of your deposition. You should be as well prepared for your deposition as you are when you step into a courtroom to testify in front of a judge and a jury. Because the lawyers in the case, and particularly the defense lawyers, will be citing your deposition testimony at the time of trial. If you give a good deposition at your time of trial, make a good witness, have a much better chance of settling a case for a fair amount of money on your behalf and avoiding certainly the difficulties, time, inconvenience of proceeding to trial on your behalf. I will typically not ask you any questions at the deposition. Occasionally I do that to clarify information or testimony you've given earlier. But realize that the deposition, again, is a tool that the defense attorneys use. I will likely be taking a deposition of the other parties involved in the case, the people we're suing. So they may be present in the room. You have a right to be present under the New Jersey court rules for their deposition testimony, and they have a right to be present for your deposition testimony. They cannot interrupt the proceeding when you're being questioned, and vice versa. You cannot interrupt their deposition testimony. Typically, other family members, witnesses are not present at the deposition. Generally speaking, if they're not parties to the case, we have a right to exclude them. Occasionally, we will allow their presence. If you have somebody who you want to come, who you feel would be supportive, the defense attorney may allow that. You should ask me that in advance, but that person will not be able to help you in answering these questions. Once you get into the room, you're on your own. I liken it to a tennis coach at Wimbledon, or one of these big tennis tournaments that you may have seen on TV. The coach will talk to the player before, they talk to him after the match, but he can't call timeout, he can't go in and coach the player, he can't waive instructions from the stands. And once you get in the room, the other attorneys begin the questions. Under our court rules, the deposition, generally speaking, will not be interrupted unless you need to use the facilities where there's some emergency. So we typically go until the questioning is finished. If we do take a break, you can't ask me questions about the testimony you've given, and I can't give you any further advice. So it's important that you understand that. Always tell the truth at the deposition. And if you don't know the answer to a question, then you say you don't know. I hope you will know the answers to the important questions at your deposition. You will often be asked for estimates during your deposition, typically as to dates, time periods, things of that nature, speeds of vehicles in a car accident. It's important that you give accurate approximations. Often I'll hear somebody say, well, I was stopped at that red light for 5 minutes. Well, that is invariably not true testimony, because red lights are not typically red for 5 minutes. It's usually less time than that. We should talk about those things when I meet with you and we discuss the details of your case. If you're thinking about those questions and preparing your deposition testimony, take a wristwatch or some type of watch with a second hand and try to time how long you were stopped at the red light, for instance. That will help you give an accurate estimate. In car accidents, I also find that people often make mistakes as to distances. If you saw the other car 5 car lengths before it hit you, for 5 car lengths, it was 5 car lengths away when it hit you, then that might be somewhere between 75 and 90 feet. Okay, somebody might say they were 20 feet away, or 50 yards away. You have to give accurate estimates. It may be advisable for you to go back to the scene of the accident before your deposition, particularly in a car accident case, because you will be asked detailed questions as to where the stop signs were, what type of traffic lights there were, what the establishments or buildings were at the corners if this is an intersectional accident, if you're a pedestrian, whether there's a painted crosswalk, things of that nature. So it's always wise to go back and look at the scene of your accident before your deposition. It's also important for you to know that depositions are often adjourned. If I'm on trial in court, your deposition may be adjourned. If the defense attorney is on trial, your deposition will likely be adjourned. The trials take precedence or other legal matters that we as attorneys are obligated to attend before we attend a deposition. We have a period of time to conduct your deposition. It's called the discovery time. It's several months long and gives us ample opportunity under most circumstances to get your deposition done. There is some inconvenience to you, I realize, because of the way the court system works. What we typically have you do is call our office at around 3 o'clock the day before your deposition so we can confirm that it will in fact go forward on the next day. So often speak with us if you need to make special arrangements, get the day off from work, get care for your children. We'll try to confirm the deposition in advance, well in advance of the date. If you're unavailable when you get a deposition notice from us, for instance, the deposition is set up on a Thursday at 2 o'clock and you're not available at that time, let us know. We can schedule the deposition somewhat around your schedule, particularly early in your case. As we tend to get toward the end of that discovery period, then we have to get your deposition done and we have less latitude as far as rescheduling or finding a time that's convenient for you. But understand how the system works, so that you will not be inconvenienced. I generally try to do the depositions the first time they're listed. I want to move your case forward, even though we have several months to do that. But typically the defense attorneys, they often have depositions in older cases, other matters, and we do find that they're often adjourned, sometimes as many as 2 or 3 times. We'll do our best for you not to inconvenience you in that regard, but some of that is beyond our ability to control. Insofar as your injuries in the accident, there are a couple of things that are very important. One is knowing your medical records. Again, I understand you're not a physician in all likelihood or a medical professional, but you can go through those records. Typically now hospital records are typed. They have your complaints in there. There's certainly occasions where somebody will go into the hospital, have one complaint, and by the time we get to their deposition, their primary complaint is something else. They may have had some head trauma. So they have a headache in the hospital. When they get home the next day, their neck hurts and they end up having, for instance, a herniated disc in their neck. So it's important that you know what you complained about at the hospital and when you began to feel pain in the different parts of your body that were injured in the accident. As you can understand, it presents difficulties for your lawyer in getting you a fair settlement if you indicate, for instance, that you didn't, for instance, if you have a neck injury and that's your primary injury in the case, if you can't say when your neck first began to hurt. Typically, if you look at the records, you'll have a pretty good idea as to what you told the medical professionals. You may, for instance, remember that your neck hurt shortly after the accident, but that's not reflected in the records. Well, then you need to tell the truth and say what you remember about that. Sometimes the medical professionals make a mistake. However, typically they don't. When I go to a jury trial, the jury is most likely to believe those disinterested third parties who have nothing to gain or lose by the outcome of the case. So if an EMS worker shows up or a doctor from an emergency room testifies, they're going to testify as to what's in the records. So if you're not certain, then I suggest that you follow what's in those records, what you said to the medical professionals and what's recorded in those records. Again, you have to testify honestly. That is the golden rule here. But if you're not sure, these records should refresh your recollection, and you should realize it's probably in your best interest to agree with what is recorded as being said by you during the course of your treatment. You need to have a general understanding or chronology of your medical treatment. For instance, you need to know when you saw your doctor. Okay? If you had 6 months or 8 months of physical therapy following the accident from an orthopedic doctor or a chiropractor, you need to know that. You do not need to know precisely every date that you went to see the doctor. In other words, you don't need to know I saw him on February 2nd of 2010 and then I saw him next on February 5th of 2010. That's not necessary. But you need to be able to say, I saw the doctor 2 or 3 times a week for therapy for a period of approximately 4 months. You may have been sent for MRI testing. MRI testing typically results from a complaint of radiating pain. In other words, if you have a neck injury and you have pain radiating into one of your arms, that might be an indication to your treating doctor that you have some type of disc injury in your spine. He's likely to send you for an MRI. He may send you for what we call an EMG-NCV test. EMG-NCV test is where they stick all the little wires to your arm. It's usually done by a neurologist. And then there is a printout that shows whether or not you have any nerve damage. The MRI is when they put you in the long tube. They take pictures similar to x-rays of your back and your neck typically. The MRIs are able to take a picture of the soft tissues, the discs in your back and your neck, and that's why they're done. X-rays only take pictures of the bones in your back and your neck. But the MRI will typically show whether or not you have a disc injury. You should know the results of those tests. If, for instance, you had a herniated disc in your lower back, and you were to testify, well, my doctor never discussed the results of those tests with me, it's very hard for your lawyer to argue on your behalf that that you have a significant injury to your lower back, for instance, a herniated disc. I would anticipate that your doctor has discussed that with you, and if he has, that is something you should remember, and it's something you should testify about. If you had a broken bone, of course you should know that. Can't imagine you wouldn't. But occasionally I do find that a lot of time has passed, often 1.5 years, 2 years, from the time of the accident to the time of the deposition. You may be completely done with your treatment. You may want to forget this ever happened to you. It's a bad memory, and you might want to move on. But it's important that when you come to the table to give your deposition, that you generally know the results of those diagnostic tests. Listen, if they're negative, that's not a problem. But if they're positive, it indicates that you had a fairly significant injury, something that was worth noting on that test, and you need to be able to say what it was. Again, you don't necessarily need to know I have a herniated disc compressing on the thecal sac at the L4, L5 disc space. But what you need to know is I have a disc injury in my lower back. Right? In layman's terms, you need to be able to recite your understanding of what the problem is. Your complaint should be consistent. If you have a herniated disc in your lower back, that I expect, medically speaking, it could cause radiating pain down one of your legs. If you're testifying I have a herniated disc in my back and my hand goes numb, then that is medically inconsistent. So these are things that we need to talk about. Again, your complaints are likely to be recorded in your medical records. You need to be familiar with them. You should also be aware that the defense attorney may ask you who referred you to your treating doctor. So you should be prepared to answer that question, whether it was your Uncle Billy or your Aunt Sally or your cousin or whoever it was who said, hey, this is a good doctor, go to him. He handles these types of injuries. You should be prepared to answer that question as well. So you want to know your medical chronology, you want to know the significant injuries, you want to know about when these diagnostic tests, MRIs, EMGs, NCVs took place. If you had any type of pain management, injections, things of that nature, then you need to know that as well. You need to know when you finished with your doctor, when was the last time you went and saw him. You need to testify about the medications you took and how long you took them. If you use some type of medical device, a TENS unit, you need to know that, how long you use that. If you use a back brace or still use a neck brace, please bring that to our attention. Those types of medical devices you should hold on to. We may want to use them as exhibits at the time of trial. If I have a pristine white neck brace, I don't want it because the jury's going to know you didn't use it. What I would expect if you use the device is it's going to be a little raggedy, it's going to be perhaps a little bit dirty, but it's going to show some use. If you continue to use those things, hang on to them. If you're deciding to get a new one and throw out the old one, don't throw out the old one. It may be important evidence in your case that may convince a jury objectively that you did use that device. In other words, juries are meant to be skeptical. They're supposed to weigh the evidence, decide who's telling them the truth. So any type of corroborating testimony, corroborating exhibits that we can give to the jury is going to help us prove our case. Typically at the end of the deposition, after going through your background information, any prior accidents or injuries, your health history, how the accident happened in great detail. One other thing there I want to mention is I'm almost certain you'll be asked what part of your body struck what part of the inside of the car or the pavement if you're a pedestrian or this is a fall-down accident. They will ask questions like that, which will require you to think long and hard about exactly what happened. For instance, if you have a knee injury following a car accident or following a fall down, I would expect there would be some testimony that there was some type of trauma to the knee. The way this is typically done, for instance, in a car accident case, is the insurance lawyer will ask you, did any part of your body strike any part of the inside of the car after the accident? If you say, for instance, well, I was thrown forward, I had my seatbelt on, my chest struck the steering wheel. Anything else, Mr. Plaintiff, that struck any part of the inside of the car? And you say, not that I can recall. Well, if you had a knee injury and you have, for instance, a torn meniscus in your knee, which is typically caused by a twisting or some type of trauma, I will have some problems proving that for you at the time of trial because we have no recorded trauma to your knee. And that may very well have happened in the car accident. You may have been thrown forward, struck your chest, and that's what you remember, but you may have twisted your knee, or your knee may have struck the dashboard, and that's how you were injured. Remember, we have to prove your case by what they call a preponderance of the evidence. That's the greater weight of the evidence. That means it more probably than not happened in this accident. As we get some mileage on us, as we get a little bit older, our bodies tend to degenerate. You have bad knees, you have bad backs. Often I find that these cases boil down to a question of medical causation. The defense insurance lawyer realizes he's dead to rights. His client rear-ended you on the New Jersey Turnpike. He was going 30 miles an hour. You have injuries. The only way he's going to win his case is try to blame those injuries on old age, some prior accident, some other occurrence. You only give him ammunition when you're unable to say precisely how the injury occurred, in the sense that the mechanical happening of the accident, the trauma to your body, resulted in a particular injury. So you need to be able to say, yes, I slipped on that banana peel, and it was my right knee that struck the ground first, for instance. Again, we don't want you to create anything that's not true, but you need to think about this and be prepared for these questions. Again, if you want to discuss it in advance with me, I'm happy to do that with you. In addition to knowing the mechanics of your injury, you have to know, again, the chronology. You have to know the important diagnostic tests, the treatment. You need to know what your doctors said to you when they discharged you. They may have said, come back if you need to see me, or there's nothing further I can do, or if you have problems, go to the hospital or call Dr. Smith. That will typically be in your treating doctor's report, so you want to look at that. Finally, at the end of your deposition, when you're tired, you want to go home. This is usually when the insurance lawyers will ask you a couple of very important questions, and you need to be prepared for them. They will generally ask you at that time, what's still bothering you? In other words, you may have had a neck injury and a back injury, and perhaps your neck is feeling pretty good. Perhaps your back is not. You need to tell them precisely what your complaints are. If you say, my neck hurts a lot, that will certainly engender additional questions. That doesn't describe anything. A lot, a little, those types of words. The lawyer will typically say, well, how often does your neck hurt? If you can say in a typical week it hurts me twice a week, you can expect questions, what causes the pain? Well, if I try to pick something up, if the weather's bad, or perhaps for no reason. When I wake up in the morning twice a week, generally my neck is very stiff and it hurts me. Whatever the truth is, you need to be prepared to tell the lawyer. So you need to be able to give them a concrete idea as to the frequency of the pain that you are experiencing in the particular body part. Your back may be different. You may say, my back hurts every day. I'd say generally for an hour, and that is made worse by my exertion, by trying to pick things up. Whatever it is that aggravates that pain, you need to tell them. Again, think about these questions because I'm almost certain you'll be asked to respond to these questions. In addition to the frequency of the pain, they're going to ask you for the severity of the pain, or to describe the pain. Is the pain a dull ache? Is it a sharp pain, like somebody is sticking a knife in your back? They'll ask you again, does the pain radiate? By that they mean, does the pain travel? Does it start in your back and then travel over your thigh and into your knee? That's a typical symptom of a lumbar or lower back herniation. So if that's the case, you need to tell them. And you may say that my back hurts, every day. Once a week, I feel it traveling into my leg. Whatever your complaints are, you have to be prepared to articulate them. Also, the attorney will ask you about any limitations that you have. For instance, I used to carry the groceries up the stairs. My husband has to do that for me. I used to go out and shovel the snow in the winter. I used to go to the gym 3 times a week, and I can't do that. So you need to give them your limitations. They typically break that down into 2 areas. Things that you cannot do anymore. What they mean by that is things you don't do anymore because they're too painful. For instance, if I used to lift weights, but then I hurt my back in an accident and I gave it up, well, I might be able to lift a weight on occasionally, but I will pay for it later. So that would be something that I would respond to affirmatively. When a lawyer asks me, hey, what can't you do anymore as a result of this accident? Well, I used to lift weights about once a week, and I had to stop that because I found it was too painful for my back. Next question may be, well, did you ever try since this accident? Yes, I tried 2 or 3 times. I realized I couldn't do it without a lot of pain, so I stopped doing it. I used to play soccer on the weekend. Go out with my buddies in the park. It was a nice day. We'd kick the ball around for an hour. I had to stop doing that because I get this pain in my back, which would go down my leg, and it simply wasn't worth it. It was too painful. I had to stop that activity. I don't pick up my children anymore. I have a 4-year-old. He likes to roughhouse with me. I can't wrestle with him anymore because that bothers my back. Those are some good examples of what I've heard over the years, and you need to be prepared and think in advance of how you're going to respond to this question about your limitations. In addition to those things that you can't or don't do anymore, the lawyer will ask you to give him, he'll say, tell me all the things you have trouble with now. Again, this is a limiting question, all right? When I say it's a limiting question, the lawyer hopes to limit your testimony in your deposition. If you say, I have no limitations, or I can do everything, or the only thing I have problems with is carrying out the garbage cans on Tuesday nights, so I don't do that anymore. When you go to trial, if you remember additional things, and you say, oh, I forgot, I can't play softball on the weekends, or I can't do whatever. I can't vacuum the living room anymore because it's too painful to bend over. That will not be in your deposition transcript. You can be certain that the lawyer is going to confront you with your deposition testimony and say, didn't you tell me on such and such a date in your lawyer's office at your deposition that the only limitation you had was blank? So you want to be prepared to tell the lawyer all of your problems when he asks one of those limiting questions. You may want to respond to that type of a question and say, well, my back hurts me with almost any type of physical activity. All right, that prevents him from limiting you. You can say, if I try to play softball, if I play golf, when I cut the lawn, all of those, you can give him examples. But again, we don't want you to, quote-unquote, gild the lily. Don't make things up. Be honest in giving your complaints. So that's a synopsis of generally the types of questions that you're going to be asked at a personal injury deposition. Every case is different. You can be certain that if I'm handling your deposition, if I'm going to be present with you and preparing you, I will have read your file thoroughly before the case, so I'll be aware of all the documentation that the defense lawyers have. You can be certain that the defense lawyer will have thoroughly read the case, he'll have prepared for the deposition, and he'll be prepared to ask you all of the relevant questions. If you want your case to go well, if you want me to be able to maximize your recovery for you, you need to make a good appearance, and you need to be prepared, and you need to be able to articulate all of the things that we've just talked about. The happening of the accident, your prior history, particularly your medical history, your chronology as far as your treatment, what doctors you saw, what they did for you, the important results of those diagnostic tests, the mechanics of the injury, exactly how you hurt your knee or your back. If you hurt your shoulder, did it twist in the accident? We need to provide a factual basis for that injury. And lastly, you need to be able to give your present complaints and your limitations. I hope you found that this information is helpful to you. It will save us a lot of time and enable us to concentrate directly on the specific facts of your case and the information that I think you have to be aware of in order to testify accurately, honestly, and well, so that we can do the best that we can for you in this case. We again thank you for hiring us to be your lawyers in your personal injury case. We want to do our very best for you. If you have any questions or concerns about what I've said today, or about any of the facts or circumstances, or the status of your case, please be certain to give us a call, and we'll be happy to answer those questions for you. Thank you.